incident, whatever the facts may be on that, did that or did that not contribute? We just don't know enough about that to say that it was not something that contributed to his later injuries. So these are the kinds of things, when you look at the pain and suffering now and in the future, he may well have pain and suffering. He has this congenital back problem. He had it early on. Dr. Yeager noticed that. Dr. Wolf noticed that. That's a consistent condition. But that, ladies and gentlemen, is a congenital condition that has nothing to do with the accident and may give him problem in the future, but that is not something.
Ladies and gentlemen, it is our belief, and we believe the evidence clearly shows, that not only was Elmo Johnson not negligent, but that the plaintiff, Ricky Jones, was negligent in 1, failing to keep a proper lookout, and 2, failing to yield the right-of-way to traffic on Weberville Road. And remember, as we discussed earlier, negligence means failure to exercise ordinary care. Why do we say that Ricky Jones failed to use ordinary care? Let's review some of the evidence you've heard from the stand. First, M. Lewis, a witness called by the plaintiff, stated quite clearly that leaving the school and entering onto Weberville Road is a very dangerous thing. She told you that there is hardly time to get out there without getting hit. Second, S. White, a fellow employee of Rick's, also told you that the intersection is a very dangerous place. She stated that it is almost impossible to get out onto Weberville Road when a car is in your vision to the left. In other words, even under normal conditions, people who were familiar with the intersection, as Rick Jones either was or should have been, knew that you had to be very careful to avoid a collision with traffic passing on Weberville Road. Was Ricky Jones careful? No. He told you that he saw Mr. Johnson's car out of the corner of his eye as he got onto the road. And more importantly, he admitted that he thought it was going fast. That is, he deliberately pulled out in front of a car he thought was going fast. Now, ladies and gentlemen, I put it to you, does a person using ordinary care pull out in front of a car which he thinks is going fast when he knows that the intersection is dangerous under normal conditions? We submit that such a person would not do so. He would simply wait until the traffic was clear. In addition, the judge will instruct you as to the law regarding entrance onto a road from an intersecting street with a stop sign. When you review the evidence in the jury room, you must require of the plaintiff that he meet the strict standards of that law. Otherwise, he has failed to use the proper degree of care. Ladies and gentlemen, it boils down to this. Either Ricky saw Mr. Johnson's car or he did not. If he saw it, we submit that he was careless in pulling out in front of it at an admittedly dangerous intersection. If he did not see Mr. Johnson's car, then we assert that he was careless in failing to keep a proper lookout. Either way, Ricky was negligent. So when you answer the special issues, we would urge that the only reasonable answer to issues 12 and 14 is yes. Issues 13 and 15 deal with the concept of proximate cause, as we have discussed before. Remember, there can be more than one proximate cause of an injury. We submit that the only possible answer to issues 13 and 15 is yes. Yes, Ricky's failure to keep a proper lookout was a proximate cause of the accident. And yes, Ricky's careless entry.
Ladies and gentlemen of the jury, I've been talking to you for some time about the damages incurred by Ricky Jones in this case. I've talked to you about medical expenses in the past, about medical expenses in the future, about lost wages, and about lost wages in the future. These measures of damage are very easy for you to quantify. Lost medical expenses is merely how much you spent for medicine, drugs, and doctor's treatment, hospital bills. Lost wages is just how much he lost from salary and wages as a consequence of his accident. But right now, we're going to have to discuss the most difficult element of damages in this case, and by that I refer to pain and suffering incurred by Ricky Jones. Special issues 16, E, and F. Pain and suffering is extremely intangible. Perhaps your most difficult job is to quantify that damage. I don't really know how to tell you exactly how much pain he suffered, like on a scale of 1 to 10. And even if I could, I don't know how to assign a monetary value to that pain. But we must do the best we can. Ladies and gentlemen of the jury, don't allow the fact that it's difficult to quantify this pain make you feel that it's any less real, that it's in any way a lesser form of damages than the medical expenses or lost wages, because it's very real damage and it's caused by defendants. It's something that has been incurred by plaintiff, and I think you need to compensate him for it. You've sworn to do so when I talked to you at the beginning of this trial on voir dire, and I'm calling upon you again to do so. Defendant counsel asks that you have tolerance for Ricky's pain, that in your minds you tolerate the pain he's going through and minimize it to a certain extent. Although your minds can tolerate this pain, Ricky's body cannot tolerate the pain. He feels it every day of his life. His health has been ruined, health which we hold most dear. He's incurring pain, that which men fear most of all. And defendant caused that loss to Ricky. Although I can't directly explain to you what this pain is like, I feel that I can get to it indirectly, and this is my most difficult task. I'll confide to you. First, let's think about the accident itself. An accident where Ricky, on his motorcycle, was hit from behind, catapulted into the air, and came down on his head. The impact of the motorcycle was so great that it pushed a car in front of him 2 or 3 feet forward. So great was the impact. You've seen in evidence a picture of the motorcycle, how mangled it is beyond belief. But a motorcycle can be repaired. We can replace fenders, we can straighten out the frame, but we cannot do this to a man. And a man feels pain when his body is mangled. And I believe that this is what happened to Ricky. So in thinking of this accident and thinking of the pain, think of what happened to the bike in the accident to give you some idea of what the pain that the man felt must have been like. In earlier testimony from Dr. Yeager and Dr. Wolf, they held up a model of a human spine. Think about this spine when you go back into the jury room to deliberate on pain and suffering. They showed you how one of the lower vertebrae was knocked out of joint, one of the vertebrae that takes the most stress of daily activity. Ricky has testified that every time he breathes, he feels pain, that every time he bends over, he feels pain. Unlike the model shown to you by the doctors, this pain is real, and a man feels a lot of pain that perhaps isn't adequately represented by just a plastic model. So think of that model, think of that vertebrae being knocked out of place, and think of how that must feel to a man. Lastly, think about what Ricky can no longer do as a consequence of this accident. He can no longer drive his bus properly without feeling some pain. Normal sport activities, extremely difficult for Ricky to engage in. Merely breathing, bending over, things of this nature always cause him pain. Try and put a value on that pain. Ladies and gentlemen of the jury, we feel that $5,000 for past pain and suffering is reasonable, that $5,000 for future pain and suffering is reasonable. These are our figures. We feel that they're reasonable. We feel that they accurately represent Ricky's loss. Ask yourself how much more you would pay to perhaps have a tooth filled with Novocaine than without, to get some idea of the pain. Try and quantify it in terms of how much money Ricky should receive for having to draw a painful breath. I submit to you that our measure of damages awards him a fraction of a cent for each painful breath he draws, approximately 30 cents for every day of his life that he lives in pain. We do not think that this is unreasonable at all. Ladies and gentlemen of the jury, in closing, I would just like to ask you to consider this fairly, to realize the pain he's gone to think about the accident, to think about the spine, to think about what he can no longer do, to think about how much more you would pay to have a tooth filled with Novocaine than without, to get some idea of the pain that he is going through. I would tell you that defendant caused this pain to Ricky that is an actual element of damages, just like medical loss or lost earnings, and that it should be compensated for. So I ask you to go back into the jury room and deliberate, and I ask you to come out and in response to Special Issue 16E and F, answer $5,000 for past pain and suffering.
Ready? Okay. Members of the jury, you will also be asked to determine when you are in the jury room what sum of money would fairly and reasonably compensate Ricky Jones for the physical pain and mental anguish that he has experienced as a result of this accident. The pain and suffering that he's experienced in the past, and also that pain and anguish that continues into the future. You will record the amount of the compensation that you will award him when you consider Special Issue number 16, subsections E and F. Calculating damages for physical pain and mental anguish is never an easy task. However, when this trial started, if you recall, each of you agreed that you would set yourself to that task of determining amounts for physical pain and mental anguish if the evidence would warrant an award of such damages. I submit that we have presented during this trial ample evidence to support your awarding an amount of $10,000 to Ricky Jones for physical pain and mental anguish. That would break down to $5,000 for the physical pain and mental anguish that he's experienced in the past, and an additional $5,000 for the pain and anguish that he can reasonably be expected to experience in the future. Let us review the evidence that you should consider when making this decision. First, you heard testimony that before the accident, Ricky Jones was a normal, healthy, active, and strong young man of 22 years. In addition to being active in his personal life, he also held jobs that required much physical exertion. He did heavy lifting and carrying when he was a plumber's helper and a carpenter's helper. He worked long hours every day driving a big school bus that didn't even have power steering. Never in this time did Rick ever complain of backaches or pains of any kind. Before the accident, Ricky had never even really been to see a doctor. He was not under any kind of medical treatment. As you evaluate the evidence and the extent of Ricky's pain and suffering, it's important that you recall the events of the accident itself. If you recall, Ricky was sitting on his motorcycle, stopped on Weberville Road, fixing to make a left-hand turn onto Decker Lane. He had his feet on the ground, resting, when suddenly the Buick Riviera, driven by defendant Elmo Johnson, came speeding down the Weberville Road and smashed into the rear of the motorcycle. The impact threw Ricky into the air 10 feet, and he came crashing down to the ground on his head. If you recall the testimony of Mr. J. Howard, who saw the accident and who said that at first he feared that Ricky had been killed by the accident. It was that horrible. You also heard testimony as to how the extent of Ricky's injuries immediately after the accident. If you remember, he had bruises and sprains and scrapes and dislocations over virtually his entire body. Since the accident, Ricky has received continuous medical treatment. Doctors have testified that a pre-existing condition known as spondylolisthesis, a condition that Rick didn't even know he had before, was aggravated by this condition. Dr. Wolf even testified that Ricky may in the future have to undergo a painful back operation. Ricky himself has testified that he's had many problems since the wreck. He feels backaches and pains throughout his body that he never ever felt before. Ricky Jones is a young man. He's 25 years old. He should be in the prime of his life. It is unquestionable that the accident has robbed him of much of the vigor and vitality and activity and carefree pleasure out of life that a man of his years should be expecting at this time. As I mentioned earlier, it's very difficult to calculate damages for pain and mental anguish. How do you measure something like the pain of chronic backache or the anguish of not being able to get out and enjoy yourself as you used to be able to? Nevertheless, I think the evidence in this case makes it quite clear that Ricky Jones is entitled to fair and just compensation for his injuries and for the extent of the physical pain and mental anguish that he's experienced and that he'll continue to experience in the future. Therefore, we request that you award an amount of $5,000 for the physical pain and mental anguish of the past and an additional $5,000.
Ladies and gentlemen of the jury, the plaintiff has alleged in special issue number 10, which we will get after we finish here, that the defendant Elmo Johnson was intoxicated and that intoxication made him incompetent to drive a motor vehicle. Now let me remind you that the plaintiff in this case has the burden of proof. In other words, on each one of these special issues that they will be given, the plaintiff is required to prove by a preponderance of evidence his position. The defendant, Elmo Johnson, need prove nothing. Now, the only evidence that the plaintiff produced on this question of intoxication was the testimony of Jay Howard. Now, if you'll remember, he was also the witness who testified about certain things that the state trooper said to Elmo Johnson, which the state trooper then on the stand flatly denied. Now, Elmo Johnson admitted having maybe 3 beers on the day of the accident from 12:30 to about 4:30. But remember, the court charges you to determine whether he was intoxicated so that he was incompetent to drive a motor vehicle. Now, we presented evidence, although we didn't have to say anything, that there were 5 other people who were in close contact with Elmo Johnson on the day of the accident, and none of them saw any evidence of alcohol. First, there was H. Baker, the car salesman at Brumley Buick. Now, he talked to Elmo for 5 or 10 minutes, pretty much checked him out, didn't see any signs of alcohol, didn't ask for his driver's license or anything before entrusting him with this Buick Riviera car. Okay, Elmo went out on the street and was involved in this accident with Rick Jones. The accident was investigated by the state trooper Officer Smith, whose testimony you heard here on the stand. Now, Officer Smith told you that he is very strict on drunken drivers, that if he sees any sign of alcohol at all, he will administer some test and find out and then take the driver in. He had Elmo Johnson in his car. He talked to Elmo Johnson. He didn't give him any test. He saw no signs whatsoever of any alcohol with Elmo Johnson. Okay, you also have 2 other people. The woman who was turning left testified that the defendant had no signs of alcohol on him, and then you have the man who was behind the plaintiff when he pulled down on the street testifying that there were no signs of alcohol. And finally, the plaintiff himself, Rick Jones, who was on the ground, was helped up by the defendant, talked to the defendant. Even he, upon the stand, couldn't give any testimony, said that he saw no signs whatsoever of alcohol on the defendant, Elmo Johnson. Now again, the plaintiff has the burden. He has to prove by a preponderance of the evidence that Elmo Johnson was intoxicated and that intoxication made him incompetent to drive a motor vehicle. It's clear with these 5 people who were in close contact with Elmo versus the one testimony of a witness who was impeached and whose credibility was questioned.
Ladies and gentlemen of the jury, the plaintiff has talked to you today about what they think the issues are, and they've described the accident, and they've talked about damages and how the plaintiff supposedly has been hurt. But I'd like to talk to you about what I think is the main question, and that is who, if anyone, was at fault in this unfortunate accident. Who caused it? Who was, as they say, negligent in causing this accident? Now, the plaintiff has claimed that the defendant was driving like a crazy man or was just speeding completely out of control around this ultimately and impossibly dangerous intersection. But I think if we look at the facts, as you've seen in evidence, we'll see that that's not exactly how it turned out. Now, before I talk about the accident intersection, I'd like to go over a couple of things that the judge has mentioned to you about what it means to be negligent. Now, the first thing he talked about was ordinary care. Now, that makes sense. That makes common sense. It's just what an ordinary person, a reasonable person, would do in this situation. No trouble with that. Now, negligence is just the opposite of that. It is the lack of ordinary care. What a reasonable person should do, but was not done. I don't think we have any trouble with that. Now, the plaintiff is claiming that the defendant in this case, Mr. Johnson, was negligent. He was the one who did not exercise ordinary care. Again, I say I think the facts show that is not the case. That if anything, Ricky Jones, the plaintiff in this, was equally at fault. Now, in the testimony, the plaintiff drew a map on the board, you can see, that shows the intersection, how there was a curve, and it intersected Decker Lane and Weberville Road. Now, the plaintiff would have you believe that this intersection was the curve was right by the intersection, right by where Ricky Jones came out of the street. That Ricky Jones was just trying to pull out like a normal person, and the plaintiff, Mr. Johnson, the defendant, came speeding up like a crazy man and smashed into the plaintiff. But if you recall that drawing, from that curve over to the intersection was almost 300 feet. That's the length of a football field. Now, in that entire 300 feet, Mr. Johnson, the defendant, could see Mary Lewis's car for 300 feet. He could see Mary Lewis's blinker turning to turn left on the Decker Lane for 300 feet. He was exercising complete lookout. He was looking all the way as he was going for 300 feet. Now, that sounds like something the ordinary man would do. He wasn't speeding along. He wasn't driving like a crazy man. He was watching and could see what was going on for 300 feet. Now, what was the plaintiff doing in this case? The plaintiff says in his testimony that, well, he's not sure, but he doesn't remember seeing the defendant at all. Was the plaintiff looking? Was he trying to see if there was a car coming? We have no evidence of this. All we have is the evidence that Mr. Johnson was looking and could see for 300 feet, almost 300 feet, what was and what was not, that's the important thing, what was not in his lane. So if anything, it seems like Mr. Jones was the one who has failed to exercise proper lookout. And the second point on this is, even if Mr. Jones did see, which we dispute, even if he did see the defendant's car, then why did he go ahead and pull out in the road? On this issue, let's see, special issue number 13, below that it talks about a legal requirement that a person pulling onto a road, say pulling on to Weberville Road from the Travis State School, that they are required to yield the right of way if a car is coming in main traffic. Now that's just common sense again too. You don't pull out in front of a moving car. But what is the evidence we have here? Again, Mr. Johnson has 300 feet and never sees the plaintiff, Mr. Jones, in the road. He sees Mary Lewis's car, but does not see the plaintiff's car, the plaintiff's motorcycle, until at the last moment, what happens? The plaintiff's motorcycle darts across the road and collides with Mr. Johnson's car at an angle, mind you. Not ended like this, not straight on, but at an angle at the front of Mr. Johnson's car. Now what does that sound like? That sounds like to me that Mr. Jones, the plaintiff, darted out, came across the road into the line of traffic where Mr. Johnson was driving. And that sounds like failure to yield the right of way, something that we're all required by law to do and seems like required by common sense to do. So that's the second issue of this, was that even if Ricky Jones looked, which there's no evidence of that, why did he pull out in front of a moving car? That doesn't make any sense at all. Both of these together go on to show that if he failed to exercise proper lookout and if he pulled out in front of a car, these were the proximate causes of his accident, not just Mr. Johnson driving on the road. Because if Ricky Jones was not out in Weberville Road, if he hadn't pulled out in front of the car, if he had looked where he was going, this accident would never have happened. So that's the question we would like you to talk about and think about mainly. Is not the damages, we'll talk about that some, but mainly who, if anyone, was at fault in this accident. Now, Mr. Johnson may have had something to do with it. He may have been going too fast. There's evidence that he was speeding some, and that may be the case. But approximate cause can also be because the plaintiff was not exercising reasonable care, ordinary care, when he failed to look and when he pulled out in front of Mr. Johnson's car. And that, we think, is equally, if not the sole cause of this accident. Thank you.
No, not, she doesn't.
And this is my last question to you. During the month prior to this event, isn't it a fact that Bonnie seemed to be growing?
Your Honor, that is a leading question.
Approach your bench, gentlemen. It's outside premises and present jury. What's the purpose of this inquiry?
Your Honor, this question is going to show the motive for the crime, that she was worried and depressed and having money problems.
And what? And what specific question you gonna ask?
I didn't even get a chance to get it out before the objection, Your Honor.
Sorry to say, I'll
During-
ask you a question.
He's being very primitive, Your Honor. During the month prior to the event, isn't it a fact that Bonnie appeared to be growing more and more depressed over not being able to find a job and not being able to make ends meet on her salary as a teacher? This is a question from a statement this witness has made prior to this event.
What's your objection?
That is an extremely leading question, Your Honor.
Your Honor, I admit that it is a leading question. This witness has demonstrated his unresponsiveness. I'm simply trying to get this done quickly. He's an adverse witness to me, Your Honor.
I want you to rephrase your question.
All right.
Back in front of the jury.
Was Bonnie having any money troubles around this time?
Objection, Your Honor, that is a leading question.
Overruled.
Well, you know, Bonnie'd never have any money troubles because I make a lot of money and she could always come to me for money, so it's really hard to say she had money troubles. And she's just like, you know, you gotta know Bonnie, man.
Your Honor, I would ask that the witness be instructed to be responsive.
Instructed to answer the question and only be responsive. Don't have no narrative.
Your Honor, may I interject? It's not clear to me that the witness